Well, hopefully that quiz went well for you. But we're going to move on now and talk about some methods to discharge contracts. And when we talk about discharge, meaning terminate. How can we terminate a contract? And there are different ways to terminate different types of contracts. So let's just take a look at some of the ways you can terminate. One way is by performance, which I will tell you is the most preferred method to terminate. Again, performance. Once every or all parties have performed what they agreed to do in the contract, then it's over. We're done. So when does this happen? At closing, at least with a real estate contract, at closing. So once we've closed, that means everybody has performed what they agreed to do. It's over. Contract is terminated. But we could terminate a contract just by release. And, obviously, is it possible, not just possible, I'm telling you this is common, and it happens a lot in real estate, believe it or not, where a lot of times, buyers will make an offer, get a house under contract, and then the buyer starts getting cold feet. Or, for whatever reason, the buyer no longer either wants to purchase the property, or maybe they no longer have the means to purchase the property, whichever the case may be. Well, and then obviously, so the buyer wants to get out of the contract. Well, how do you do that? Because you're in a legally binding contract. Well, one way could be by a release. The seller could just release the buyer, obviously, and then that frees the buyer up from their obligations under the contract. They no longer have to close. But what you want to be careful with here, and especially for test purposes, there's a big difference between release and this next option called rescission. Be careful you don't get these two confused. Rescission would also mean that both parties have agreed to release each other from their obligations, but rescission takes this a little bit further. In fact, you'll notice it says here, it's in your book as well, but on the slide, says rescission puts all parties back into their original position prior to entering into the contract. So if the buyer and the seller both agree to a rescission, in essence, there was never a contract. We've agreed to go back to the position we were in prior to entering into the contract. Well, if you're to that position, then obviously that means there was never a contract, right? That matters because of the earnest money. Who's going to get or keep the earnest money when we terminate the contract? Well, if we agree to rescission, because in effect now there is no contract, there never was a contract, then obviously the buyer gets their money back. They get to keep it. In fact, it even says here that the courts would not recognize the contract as legally binding because you agreed to rescind or rescission is the method you chose to terminate the contract. Now, going back to the previous method, release, now let's be clear we understand what that means. If the seller may very well agree to release you from your obligations, but that does not put you back into the position you were in prior to the contract. So in essence, what the seller is agreeing to under release is that I'll let you out. I will not force you to purchase the property, but I am going to keep your earnest money as liquidated damages. That's a big difference there. So all that being said, between these two, release and rescission, with a release, obligations to perform have been excused, but the seller will keep the earnest money. But if they agree to a rescission, then your obligation to perform has been released, and buyer, you get your earnest money back. Because again, under rescission, it's as if there was never a contract to begin with. So, y'all, again, for test purposes, y'all make sure you don't confuse those two terms. Both will terminate the contract, but at the end of the day, which is going, depending on which one you agree to, will determine who's going to get or keep the earnest money. Okay? All right. We could terminate by accord and satisfaction, and to do this is going to require something that we call a novation in order to do this. And we'll talk about both of those. But y'all, with accord and satisfaction, basically that just means that the parties have agreed to terminate this contract and just replacing it with something completely new, completely different, whatever. So we're terminating one agreement and replacing it with another agreement. That's what accord and satisfaction means. Now, when you start replacing or substituting something, one contract for another contract, that requires a novation. And a novation, in fact, the term novation just means substitution. So assuming both parties agree to the novation, that means they've agreed to substitute. In this case, one document for another document, or one contract for another contract. You'll actually see a little bit later in the course where we'll actually be talking about novation again. And again, what does novation mean? Substitution. Now in this example, we're talking about substituting one document for another document, but in some cases you may actually substitute people, where we'll substitute this person with that person. So we'll take maybe this buyer out of the agreement and substitute them with a completely different buyer. Y'all, that's substitution or novation, okay? All right, so that's what accord and satisfaction means. Excuse me. And then we look into the statute of limitations. Y'all, I would assume everybody's familiar with that terminology or knows what that means, but if you've been harmed or suffered some damage in some way, then obviously there are legal remedies potentially you could take to remedy your loss. But you have to do it within a certain amount of time. That's called the statute of limitations. If you haven't filed some action for relief, and you haven't done it within a certain amount of time, then then basically you have waived your rights to any remedies. So you have so much time to take action. If you don't do it, then you no longer have the right to take action. That's what the statute of limitations is talking about. Now, I will say this, and I don't know that this would be necessarily all that important for test purposes, but just for clarity, because I get this all the time. Well, Frankie, what if I am harmed in some way, and the statute of limitations is you've only got 1 year to take action, but I did not realize what happened, did not realize there was a problem for over a year. It was, so basically the statute of limitations was up before I even realized what this other person did to cause me harm. Well, again, if in this example, if the statute of limitations is a year, y'all, that time frame that you have does not start until you have knowledge of the issue. So it doesn't start when the issue took place. It starts when you have knowledge that there's an issue, right? So hopefully that will be helpful. All right. Assignment, y'all, another way to discharge contracts. And y'all, there's all kind of ways you can do this. And y'all, basically what you're doing when you assign something, you're basically conveying one person's interest to somebody else. So whatever interest I may have, I'm giving it to somebody else. Y'all, that's an assignment. How does that work? What would that look like? Well, I will tell you, again, it could be used in a number of different ways, but one example that I like to use a lot is, and I know investors like to do this as well, but But y'all, let's say I find a house that's sitting there vacant, maybe been vacant for many years. So I try to locate the owner of the property to see if they'd be willing to sell it. And y'all, let's say they, obviously they're not doing anything with it. They have no intentions to use the property. So they said, oh, sure, make me an offer. Well, let's say the house was worth $200,000. In the condition it's in, which typically means it's going to be in pretty poor condition, right? Been sitting there vacant. So, but in the condition it's in, we'll say it's worth $200,000. And then so they'll get the house under contract. In fact, rather what they might do, in fact, will likely do, because, and there's a reason we call them investors. Y'all, investors typically don't pay full price, right? They don't pay the full value. Y'all, there has to be some equity there, or otherwise, what's the point? Because they're not going to live there. They're buying it as an investment to make money on it. But let's say that I convinced the homeowner to sell the property, say for $150,000. Okay. And they'll have reasons why, because you're not having to pay for any realtor commissions, and you're saving money here and you're saving money there, and you don't have to worry about putting it on the market and showing the house. They'll have all these reasons why it's a good deal. Okay. But anyway, so the seller and the buyer agree to sell for $150,000. Well, then a lot of times what the investor will do is they'll look for somebody else to actually purchase the property. A lot of times they'll put it under contract with no intentions of ever actually buying the property. So they may start marketing or advertising, saying, "Hey, look, I got this house here. It's a good fixer-upper," whatever kind of marketing they want to use. But say they find somebody interested in buying the house. Well, can the new buyer buy the house if I already have it under contract? Let's say I'm the investor. How can somebody else buy it if I have it under contract? Well, the only way they can do it is for me to convey the interest I have. In fact, let me explain this to you, and you're going to see this a little bit later in the chapter. But this is a good point to make this point anyway. At the time a buyer makes an offer, and assuming the seller accepts the offer, I'm talking about the moment they accept the offer. We're a long way from closing, obviously. But the moment the seller accepts the offer, does the buyer at that point own any legal interest in that property? And the answer is yes. All right, well, what do they own? They own what we call equitable interest, or equitable title, if you will. So the moment the seller signs accepting the offer, that conveys equitable title, equitable interest, to the buyer. Now, the buyer does not have legal title. So there's a difference between equitable title and legal title. We'll get into some more of that a little bit later. But I will tell you, you will not get legal title until closing. And you can't get legal title without first acquiring equitable title. So you have to have equitable interest in the property before you can acquire legal interest. Okay? So the equitable interest is transferred at the moment the seller accepts the offer. This is another reason why, once the seller accepts an offer from one person, and then say a day later, the next day, that same seller gets another offer on the house, and maybe it's a much better offer. Well, can the seller just terminate the offer they just accepted and decide to go with the second buyer? No, not legally, right? Because guess what? You don't have, seller, you no longer have equitable title because you conveyed it to the first buyer. And if you try to terminate it, y'all, you're going to have some legal problems. Y'all, that buyer can come back and sue you for damages because you can't convey to the second buyer something that you no longer have. Okay? And what do they not have? Equitable interest. So who has it? The buyer. So in this case, if I'm the investor, you accepted my offer, I now own the equitable interest to that property. And quite frankly, I can do anything I want to do with it. Okay? And I've decided to just sell my interest to somebody else. So maybe I put in my advertising that here we got a house, it's worth $200,000. I'll sell it to you for $170,000. Now, is that a good deal for somebody? Yeah, absolutely. Yo, they're buying the house with $30,000 equity in it, right? So let's say I find somebody wanting to buy the house. Yep, I'll buy it and I'll pay $170,000 for it. Well, the only way they can buy it is, again, I have to assign my interest, my equitable interest, to the other buyer, which, it's a piece of paper, it's a document, contract. We'll both sign it, and now I have assigned my interest to them. And what's the consideration? Because y'all got to have consideration. They're agreeing to pay $170,000. Now, you remember how much I agreed to pay the seller? $150,000. So basically, now that I've assigned my interest, y'all, I don't even go to closing because I'm not buying the property. The new buyer is. But when the buyer shows up to closing, y'all, they'll show up with their $170,000. That's what the attorney will collect. But then he's going to disperse $150,000 to the seller because that's what the seller agreed to. Well, what happened to the other $20,000? That comes to me. That would make me, because I'm the investor. And so basically, I made $20,000 on this transaction as that investor without even buying the house. Look, that's just one way that assignment could work. There are other ways it could work. I just want to give you an example there. But just make sure you know what an assignment is. Assignment means I've conveyed my interest to someone else. Whatever interest I own in the property, I'm conveying it to somebody else. We call that an assignment. Okay. And by the way, that example I just gave, that may not be legal in some states. So again, it's imperative that you know what the laws are in your state. Okay. It is legal in probably most states, but there may be some states it's not legal. So just be aware of that. All right. Now we look at ways we can terminate an offer. Oops. What I want you to be careful of here, we just talked about ways to terminate contracts. Now we're getting ready to talk about ways to terminate offers. That's not the same thing. Remember, a contract is one that's been accepted, right? It's a ratified contract. We talked about the ways to get out of it or terminate it. Now we're getting ready to talk about how do you just terminate an offer. An offer is just an offer you make, but it has not been accepted yet, but you've already made the offer. Well, how do we terminate? One way is just by rejection. The person receiving the offer may just say that this is just ridiculous. It's a low ball, for whatever reason. So the seller just says, I reject it. This isn't even close enough to try to talk about or negotiate. So it's just rejected. I hate rejection. You'd think I'd get used to it after this many years in life, but I hate rejection. I do. But anyway, that will terminate an offer. A counter offer terminates the original offer. We've been talking about that the first 2 hours in this module. Again, and I'm going to say it again. If you need to make a counter offer, make it. But just make sure that both parties understand what they're doing when they decide to make a counteroffer. You are terminating everything up to that point. It's terminated. Y'all, there's no going backwards. It's as if it doesn't exist anymore. So when you make that counteroffer and the other party says no, basically they've rejected it, then you're done. Y'all, and I'm telling you, I see it all the time where buyers and sellers say, well, but I'll do what we originally offered. And I'm telling, and you might think it I know it sounds reasonable that the seller could come back, we could just start all over again. If the seller said, all right, well, I'm just kidding, I'll accept your original offer. Y'all, I'm telling you, it rarely works out that way. Y'all, it could. But a lot of times what will happen is, y'all, you've made the buyer mad. Or if you're the buyer, then you made the seller mad. And quite frankly, they don't want to play these games with you. Y'all, there's too much money at stake. Y'all, and for most people, they're not interested in playing games. And when they determine or feel like you're just playing games here, which is what you're doing, when you start making counteroffers that you don't really even mean, no, don't come back to me later and say, well, yeah, you originally offered me $200,000, and I countered back. Well, why are you? No, I'm not going to do that no more. Anyway, y'all, I'm just telling you, it just does not work out a lot of times. And now you got a buyer all upset because now they can't get the house that they really wanted because they were being greedy. And now the seller they're not going to sell it to you. They'll find somebody else to sell it to, or vice versa. Y'all, just be careful with these counteroffers, I'm telling you. Expiration of an offer. That'll terminate, or could terminate the offer, certainly. Y'all, what we're talking about here is, y'all, when you make an offer, y'all, there should be a provision in the contract or in the offer that basically gives the seller a certain amount of time to review it, think about it, and then let me know whether if you're going to accept the offer or not. And it's typically like fill in the blank. So there's no right or wrong answer on how long you should give the seller to consider your offer. There is no right or wrong answer there. It's fill in the blank. However much time you want to give the seller, that's fine. But at least in our market, 24 hours, maybe even 48 hours tends to be common or reasonable for most buyers and sellers, at least in this market. Not suggesting that's what it should be. I'm just saying that's what you tend to see a lot in this market, like 24 hours, maybe 48 hours. But y'all, let's say we put 24 hours in the offer, meaning that 24 hours from the time we make the offer, seller, if I haven't heard back from you in terms of whether if I haven't heard from you letting me know that you've accepted the offer, then our offer is off the table after 24 hours. I'm not bound to this offer if you come back after my offer expired. Now, something that's kind of, hopefully this isn't too tricky here, but let's say the seller does come back 30 hours after they receive the offer and says, all right, we'll accept your offer. Well, they did accept the offer, but they accepted it after the expiration, the time limitations that were put in the offer. And because of that, the buyer really has an option here. Now, if they wanted to go ahead and buy the house, they can. We can still go ahead and move forward. I've heard a lot of people say, well, no, anything that happens after the expiration of the offer is just void after that point. That's not true. If the buyer, even though they accepted the offer after the expiration period, if the buyer still is okay and wants to buy the house, they can move forward and buy the house. But what this does, it does give the buyer the option to say, well, no, this was after the expiration. I'm no longer bound to the offer. In fact, I no longer even want to buy the property. So there's no contract. So really, by putting the expiration there, it really gives the buyer the option. Okay, seller, here's your deadline, and if I don't hear from you by then, I have the option to walk away, whether you ever accept it or not. Anyway, that's what the expiration does. And then revocation. Y'all, we kind of talked about this in the last hour here, but y'all, you remember us saying or talking about, can the buyer make an offer and then decide to rescind their offer without penalty? Can the buyer do that? Yes. A buyer can make an offer and then have a last minute change of mind. Oh no, I don't want to do it. I've changed my mind. I don't want this house. Maybe I found another I like better. I want to revoke or rescind my offer. Can the buyer do that? They can, as long as they have not been notified of acceptance yet, right? Again, it doesn't matter if they've actually accepted it or not. If the buyer or their agent has not been notified of acceptance, then the buyer can rescind their offer, revoke the offer, and without penalty, meaning they can keep their earnest money and there's no issues there. But now let me say this too, and I'm not sure I said this in the previous hour when it comes to this, but what we've seen happen a lot, or what I've heard about a lot, at least in my market, where maybe the listing agent contacts the buyer's agent to let them know, my seller has accepted your offer. Congratulations, look forward to working with you, yada, yada, yada. So they have notified the buyer's agent that the offer has been accepted. And then maybe a few hours later, because the buyer's agent maybe got busy or was doing something else or was just lazy, I don't know. But the buyer's agent never told the buyer, or has not yet told the buyer, their offer was accepted. And say 2 or 3 hours later, the buyer now has that change of heart. They don't want to buy no more. So they notify their agent that we don't want to buy. Again, because the buyer has not yet been notified of the acceptance. And now they want out of the contract. Well, can they now rescind their offer without penalty at this point? And the answer is no. Because the buyer's not the one that has to be notified. The moment the buyer's agent is notified the acceptance, that's it. You're locked in now. So the point I'm trying to make is that we cannot be lazy and procrastinate, put things off. As things happen, you got to let your client know what's going on promptly. If you read license law, certainly in our state, and I'm sure other states use this terminology in their law as well, but everything we do should be promptly. That's part of being the due diligence, right? You got to do the right thing. So, otherwise you're going to have these problems. Because now your buyer's going to be mad at you. Well, what do you mean you were notified of it? Why didn't you tell us? We didn't know it. Now you got a problem. Again, because you just weren't being diligent. You got to take care of stuff like this. All right. Death. Death has a way of terminating a lot of things, but it'll certainly terminate your offer. That's for sure. Obviously, if a buyer makes an offer and the buyer dies, gets killed, whatever, it's over. That offer is no longer any good. How you going to make a dead person buy property? Good luck. So, Anyway, death will terminate the offer. Y'all, it could be through some operation of law. Y'all, maybe, if you recall, we talked about eminent domain. Y'all, where could the state decide that we need this property worse than the seller and the buyer? Yes. So even though you may have that property under contract, or quite frankly, maybe you just made the offer, but if the state decides, well, we need it worse than both of you, then guess who's going to get it? The state. Y'all, that's what they're referring to there. Well, now we get into breach of contract. And y'all, and it's unfortunate, but y'all, this is common. Y'all, anytime we're dealing with contracts, just prepare yourself for one party or the other is going to violate what they agreed to do. They're not going to do what they agreed to do. Well, y'all, that puts you in breach of contract. Y'all, you failed to perform as agreed upon. And y'all, obviously, probably the most common is when the buyer just decides, I'm not buying. You know what, seller? You can keep my earnest money. I don't care. I'm not buying the house. Y'all, whatever. So, y'all, that's breach of contract. And it could be by either party. Either party not doing exactly what they agreed to do in the contract, y'all, that constitutes a breach. Well, when that happens, what do we do next? Well, there are some remedies if either party is in breach of contract. And y'all, obviously, one is they could sue for damages. If you have damage, maybe, let's say the buyer doesn't buy it. Y'all, it seems to be the most common reason that there's breach of contract. Just the buyer just backs out for no reason. So the seller feels like they've suffered damages. Well, then, they may just add up what all the damages are and send a bill to the buyer and say, well, here are the damages you've created, you caused by putting me in this position. And now you're backing out and just write me a check for this amount. Y'all, and that works good if the buyer just writes you a check and says, I'm sorry. Unfortunately, a lot of times the buyer says, no, I ain't paying you nothing. Y'all, I got to tell you, that's just pretty sorry, in my view. You call somebody else to suffer damages, then you need to do the right thing and pay up, is the way I see it. But anyway, that's the suit for damages. You could have a suit for rescission, which we already talked about. But you remember, could the buyer and seller just agree to rescission? Could the buyer go to the seller and say, look, I know I made the offer. I know I'm legally bound to buying this property. But for this reason or that reason, I just can't do it or not able to do it or whatever. And then could the seller just agree to, you know what, not a problem. I'll let you out of the contract and I'll let you keep your earnest money. No issue. I'll just put it back on the market and sell it to somebody else. Could the parties agree to that? Yes. I've actually had parties do that. I'm not going to sit here and suggest it is real common, because I think a lot of times sellers saying, well, I mean, if you just want out, I'll let you out, because at the end of the day, you can't make somebody buy your house, whether they're under contract or not. If they decide they're not buying, you can't make them. However, that does put them in breach of contract, and some of these remedies could come into play. But at the end of the day, you can't make them buy the house. And I guess it just depends on the seller on whether they're willing to just let the buyer keep their earnest money, which would be a rescission, or they may just agree to a release and, all right, well, I'll let you out of the contract, but I'm keeping your earnest money. I will tell you, from a seller's perspective, and this is a little more than probably necessary for test purposes, but I'm just telling you for good practical purposes. Once that buyer says, I'm not buying, Y'all, I think you should believe them. I think you need to take them at their word. They're not going to buy. They have no intentions of buying. Well, so seller, you need to go ahead and agree to either the release or the rescission. You need to go ahead and agree to something. Because a lot of times what sellers will do, they say, no, I'm not letting you out. I'm not agreeing to it. I'm not signing anything. I will not let you out of the contract. Well, seller, you may be hurting yourself here a little bit because you cannot put the house back on the market. You can't be looking for other buyers because you're still under contract with the first buyer that's already told you they're not going to buy. And until you get a release from the contract, you can't market it to somebody else, right? You no longer have the equitable interest in the property. So to me, it would make more sense, terminate the contract. Now, how do you terminate it? Either through a release or rescission. But you need to get one of those, you just need to go ahead and get one of those to take place, right? So that we can get the house back on the market. Otherwise that house is sitting there for days or weeks or maybe even months. And you can't do anything with it because you're still under contract with somebody that's already told you they're not going to buy the house. Sometimes you just need to cut your losses a little bit. And let's get this first contract terminated so I can now focus on what I really need to get done here. Y'all, just a suggestion. All right. Specific performance. Now look, they could ask you on the exam about any of these remedies we're going over here, obviously. But I will tell you one that I just know they love to ask about is this one. Y'all, specific performance. And basically, remember the very first one we talked about that suit for damages. So y'all, you can, tally up what all the damages are and send that bill to the buyer, assuming they're the ones that created the damage. Y'all, you send them the bill, and if they pay it, it's good. We're happy. But y'all, good luck expecting them to write you a check. Y'all, they might, but probably not. Well, if they don't just write you a check, then now what are you going to do? Well, the only option you have, assuming you want that money, is to sue for specific performance. So now basically you've taken a court action. We're now going to court. And the judge will have to look at it and decide, first of all, did you have a valid contract? Y'all, is it an enforceable contract between the buyer and seller? And assuming it is, buyer, if you're in default or in breach of contract because you did not do what you agreed to do, and the seller can show that whatever damages they're claiming are in fact real damages, then the courts will order you to pay those damages back to the seller, or vice versa, depending on the situation. So y'all, specific performance is when basically you're going to court. You are filing a lawsuit to try to force performance, either go ahead and buy the property or pay me the damages you've caused by not buying it. That's what specific performance is. And then there's what we call liquidated damages. Liquidated damages oftentimes is just some money awarded to someone when there may not be any actual monetary loss or damage. Sometimes, say the buyer doesn't buy, well, maybe there's no actual monetary damage to the seller, but it's very aggravating because now I got to go back to put the house back on the market, start marketing. I got to do all this all over again. I'm starting all over. It's kind of like for pain and suffering, if you will, for irritation. That's what we're talking about, liquidated damages. Well, how much will those liquidated damages be? How much will you get as liquidated damages? And y'all, that's going to typically depend on the earnest money. Well, how much earnest money did you put up? $1,000, $5,000, $10,000? Y'all, obviously, and we'll talk later about more about the earnest money and how you determine how much that should be. But typically, whatever the earnest money, y'all say it was $1,000, then that's what you're going to get as liquidated damages. Okay, that's what the earnest money is.